Hello, Internet. This is Hamilton Immigration Law, and today we need to talk about this birthright citizenship decision. I'm not here to break down the decision. There are plenty of great Supreme Court YouTubers and podcasters that are going to do that. What I want to talk about is what are going to be the potential knock-on consequences that the administration might pursue to try to enforce their anti-immigrant agenda. But first, the one thing I want to note is the fact that this decision was 5-4 on the constitutional issue is wild. It should have been 9-0. But instead it was 5-4, which means we're only one Supreme Court justice falling ill and passing away from this maybe going the other way down the road. That said, the first way that the administration might seek to do an end around here is with the visa application process. So if any of you that applied for a visa know that you first have to fill out a DS-160, right? You have to answer all of these have you ever questions. And one of the newest things they've added are you have to put all your social media handles so that they can go look and see if you've ever said anything mean about Donald Trump or anything pro-Palestine and then deny your visa application. But what could they do? Well, first and foremost, they could add a question to the DS-160 that just says something to the effect of, are you or do you intend to become pregnant in the near future? I mean, a lot of tourist visas are anywhere from 5 to 10 years. So they could literally ask, are you pregnant or do you intend to become pregnant for the next 5 to 10 years? And if you check yes to that question, you could end up with almost an automatic denial of applying for a tourist visa. Also, they could ask it directly to you at the time of the interview, right? Because we know a lot of times from when you fill out the DS-160, the answer might have been truthfully no, but sometimes it can be 4, 5, 6 months in between when you submit a DS-160 and when you have the interview, which means things could have changed. And at the interview, they could still ask the same question. And you may be saying, well, is someone being pregnant a reason to deny a visa? I mean, technically, no, but it doesn't matter, right? Because one longstanding Supreme Court precedent is that decisions of the Department of State are not reviewable by the courts. This allows them to do whatever they want, however they want to do it, and they do not have to justify themselves. So you may be wondering, hey, when I show up for my tourist visa interview and I'm expecting some in-depth interview and it turns out it's like 2 minutes, they barely listen to me. They're just staring at their computer, decision out. What happened? Well, again, it's because since their decisions are non-reviewable, they don't have to actually do an in-depth review. More often than not, they're basing their decision on just a profile. They're looking at your profile, your DS-160, and before you even get to the window, they probably made their decision yes or no. And then they give you a letter citing 214B, which is a generic denial that just basically says you don't qualify. They don't have to give you a specific reason why they denied you, especially for tourist visas, right? So if they see someone looks visibly pregnant, they just 214B you. They don't have to explain themselves. You can't challenge it. You're done, right? So the first could be through the visa process itself. The second then is at CBP, right? So even if you get that visa, or you maybe already have the visa, and then you fly into the United States, you first have to go through Customs and Border Protection, right, at the airport or at the land border, and they could ask you straight up also, are you pregnant? Do you intend to become pregnant? And potentially refuse entry. So there's another way they can get to you. Now, and then, of course, the third way they can get to you is, well, what if you checked no on the DS-160 or they asked you and you said no, but then you later give birth to a child in the United States? Well, guess what? They're now going to charge you with a fraud or misrepresentation because you lied on the DS-160 or in your interview or to CBP at the border, right? And now they're going to use that as grounds to permanently bar you from the country and, revoke your visa. Again, they keep a record of all of these interactions. And these days they spend more time actually going back and looking at that older record to see if there are any inconsistencies so that they can then, potentially charge you with a fraud or misrepresentation. The point here is the administration's likely not done with this issue, right? They're going to look for ways to enforce it. Now, I know there's been some chatter about, oh, maybe we'll pass a law. Yeah, good luck, right? They're not going to pass a law right now with the midterms coming up, with the divided Congress. Just not going to happen. But what they're going to do is look for ways administratively, starting with the consulates and the visa application process, right, to use a pregnancy or the potential of pregnancy as an excuse to deny people visas or entry to the United States. So this is something we need to be on the lookout for here going forward. Let me know what your thoughts are in the comments and look forward to talking to you in our next video.